everyone. A very good afternoon to every one of you from Bangladesh. Welcome to today's session, which is section 9, episode 2 of ODR webinar series sponsored by CIADR. Today, and I'll be your moderator for today. My name is Farzana Tasreen. I am a barrister at law from the Honorable Society of Lincoln's Inn, currently working as a senior legal associate in a corporate law firm. I'm also an accredited mediator for ADR ODR International and the associate counsel in CIDR, and also an executive member and administrative director of YCIADR. Before we commence to today's session, it is very incumbent upon me to say a few words about CIADR. CIDR is the first online dispute resolution center since 2018. It is the most natural and cost-efficient center established in Bangladesh and has been renowned for its very features. One of the concerns of CIDR is the ODR Institute, and there has been a lot of, it envisions the signals their persistent passion to spearhead a new era of ODR development and expansion, both for CIDR and global ODR ecosystem. Moving on to the second part of the session, where we will be introducing our guests. It is, of course, our distinct pleasure and to have such a distinct personality in today's show, who has an experience over 25 years in the legal arena, not just as a practicing lawyer, but also as an excellent arbitrator and a mediator. He is currently the director of Chartered Institute of Arbitrators, London, the CIARB India branch, the chairman of International Dispute Resolution and Risk Management Institute, Hong Kong, which is in the India branch, the Associate Counsel of Brook Chambers, London, the head India Shanghai Chuten Consulting Center Limited, Shanghai, China, director and a mediator in mainland Hong Kong Joint Mediator Center, Hong Kong. He's also the panel arbitrator for Court of Arbitration for Arts, which is CAFA, Netherlands, and the senior partner of Trust Legal, New Delhi. In amongst his various achievements over the time, he has also played a very fundamental role in terms of arbitration and mediation. He has tutored in many institutes and has honed the potential arbitrators by showing his skills and his experiences in order to become an effective arbitrator and a mediator. He has also been called as a judge in various mooting competitions. Words would be very little to say about his excellent achievement in this arena. Let me introduce you to Mr. Samisha. Sir, we are overwhelmed to have you in our show, and thank you for your time, making time to participate in our session today. We would be introducing today's topic, which is mediation, where the mediation is the ultimate appropriate dispute resolution process. Now, before I hand over the platform to Mr. Shah, I would also like to remind the audience that at the end of the session, we will be having a question answer session. You are most welcome to post your questions, and we would promise to read all the question and ask our guest special honor today to answer it. However, this is subject to the time that we have available in our hand. Without any further ado, I would be handing over the floor to Mr. Shah. Mr. Shah, if you may proceed by providing your insights about the topic today.
Thank you very much, and a warm good morning, good afternoon, and good evening from wherever you are joining. It's a pleasure to be here today on this session on for a topic which is very, very dear to me as such, because I am also promoting mediation in a very big way in our country, India. Um, and that is why when the center approached me for conducting this session, I suggested that nothing better than uh, the topic or the talk on mediation. Now, you would all have, we all are currently going through a very, very serious situation, which is the current pandemic situation, and because of this, there's a huge gloom and sadness because of various reasons. Everybody is suffering, in whether in terms of health or in terms of wealth. So everybody has suffered, and even now we don't know when this is going to be an end. However, this is not the end as such. I mean, this is a temporary phase, definitely, and things have started improving, and obviously they are going to improve, and we will be back to, I won't say normal as before, but yes, similar to that situation very soon. Having said that, obviously there has been lockdowns across various countries for maybe months to go by. I mean, in India we had lockdowns for almost 3.5 months, and even partially, even still, it is continuing in many parts of our country. And in those lockdowns, definitely everything suffers, and the most important part is economy. Now, when we talk of economy, obviously judiciary is also, or the courts are also a very important part, which plays a very important part in the economy of any country. Then, uh, I mean, talking of India and in many other countries also, there have been a backlog of cases already in the courts, and this pandemic and the lockdown, consequent lockdown, have added to those backlogs. And even now, the courts are not functioning normally or in person as they used to be earlier, and everything is happening online. And therefore, there are restrictions on the number of cases, there are restrictions on the resources for the courts to handle cases. So in this scenario, what what is the solution? I mean, you see, today disputes are happening and they are going to happen. It happens every day. You can't avoid a dispute. But what is the solution? Now, therefore, I will come to the solution part. But before we go and understand, talk about dispute or mediation for that matter, there are certain terms which I would like to discuss with you, and maybe you would be knowing about it, but these are important, aspect of understanding the subject of mediation or dispute resolution as such. And the first and the foremost term which we must understand is what we call a conflict. You see, what we have been normally saying is dispute resolution, alternate dispute resolution mechanism. We are not saying conflict, but in my view, before there is a dispute, there is always a conflict. So let us understand what is a conflict. I mean, there is definitely a difference between conflict and dispute, because, as I said, we are not saying dispute, we are not saying conflict resolution, we are saying dispute resolution. So, therefore, there has to be something different between the two terms. So, let us understand what is the difference between these two terms. So, when we are talking about conflict, if we just understand in a very simple English meaning of that, simple language meaning of that, is it is two different opinion on a same subject matter. All right. So there are many terms, so you can say disagreement, discord, or misunderstanding. All those, whatever terms are coming in your mind, all of you are right in a way. But it ultimately, what happens is that if we are taking example of two parties, so two parties are having a different of, let's say, opinion on one particular subject matter. So they are not at par so far as their understanding to a particular subject matter is concerned. So there is a difference between them. So different, disagreement, discord, whatever terms you say, it ultimately leads to a conflict. All right. Now, what, why conflict is there? Let us also understand that, because that is very important. So, so when we are approaching any issue, I mean, this is for a general understanding. This is how you should be approaching. There are some very pertinent questions you should be asking is when, what, why, how. All right. If you analyze and try to find out answers to this question, you would majorly solve the problem as such. At least you would get the link or the lead to work out on the solution of a problem if you approach with these questions. These are the basic fundamental questions you should be asking wherever there is a problem faced by you, or in whatever positions you are at that point. So why conflict? See, now conflict arises because people have different values, they have different thinking, they have different needs, they have different interests, different thoughts, different attitudes, different understanding, different cultural setup. So overall, you can say uh, a different mindset. All right, overall, uh, whatever we just discussed, different terms of interest, opinions, understanding, thoughts. Because of this differences, the conflict arises. All right. Now, what we discussed earlier is that there is a difference between conflict and dispute. So now this is what we have understand in a nutshell what conflict is. All right. Now, what is a dispute? Because as I told you, there is some difference. So what is that? What is that difference? The difference is when a legal right is added to a conflict, a legal claim is added to a conflict, that turns into a dispute. Now, let me give you a simple example. In a commercial trading transactions, all right, there is a vendor and there is a supplier and there is a buyer. All right, they have regular transaction of supply and demand, goods and commodities being exchanged. So over a period of time, they will have a running accounts balance, accounts maintained by each of the parties of their respect of each other. At the end of the financial year, they would reconcile their accounts and share with each other. So far, so good, no problem. Now, let us assume that in one particular financial year, party A has reconciled the account and sent the said account to the other part to party B, and party B had also shared the account to, and there is a difference. So, party B is saying that this is the position in my ledger, and party B is saying this is the position in my ledger. So, there is a difference. All right, there is some conflict between the two. But the moment any of these parties, all right, puts a claim, let's say party A issues a notice of demand to party B, and party B denies that notice and issue a counter notice to party A, this is the dispute. This is where the dispute arises. So long as they are just exchanging information and the account details, there is definitely a conflict. They are not same. They are not at par with each other. But the moment they put their legal claim on that conflict, that turns it into a dispute. Now, what happens? So this is what dispute is. All right. You and this is you have to understand. Conflict can be personal. It's more to do with personal aspects. But when it is added with legal claim, then it turns into a dispute. All right. So this is why we are saying dispute resolution. We are not saying conflict. If you go even by the model law, it talks about dispute. It doesn't talk of conflict. All right. I'm talking of the incidental model law. all right, or even in your general laws of your respective countries, wherever you are. But it will talk of dispute. It will not talk of conflict. So this is the reason why it says why we are talking of dispute now. So when we are so this is what is dispute. Now what happens in dispute? Now, when we say there is a dispute, and also in conflict for that matter, there is a series of exchange of information happening between the parties. So what is that? That is nothing but communication. All right, this is what we call communication. So there is a series of exchange of information between the parties happening back and forth through whatever mode. All right, so communication is another very essential aspect of a dispute resolution mechanism, be it mediation, be it arbitration, or even court litigation for that matter. So communication is another very important aspect which we need to understand what actually we mean by communication. Now, when we say the word communication, it's basically is derived from a Latin word which means to share. All right, it's sharing whatever in whatever mode, but you are sharing information with each other. All right. So what is communication? It is a purposeful and active exchange of information between two or more parties to convey or receive. All right. So somebody is saying, other is listening. So convey or receive the intended meaning through a shared system of speech or action. This is what we mean by communication. So if we break this, what are the important aspect of communication? One, there is a source. Source being the person who's speaking or the sender who's sending some information. That is a source. Second, there is a message. There's some information being sent across. All right, to be shared, opinion, whatever you call it. So there is a message being sent across. There is a channel, all right, a mode, how it is being sent, maybe by image, by body language, by action, by speech, whatever. And then there is a receiver. Obviously, I mean, you can't have a person speaking to walls or speaking to himself or herself. All right, that's not communication. So there has to be someone who's receiving that information, speech, whatever being sent across. So there is a receiver, and then there is an environment under within which this communication is happening. This can be physical, this can be psychological, a space in which the communication happens. How, in what environment it is happening. This is also important. And the context. In what context these informations are being shared. So all this together, you know, makes what a communication is. This is, I'm talking of in a very general way, but this is what actually being used when, I mean, is important when you sit in mediation, maybe as a party or as a counsel or as a mediator. You must understand these basic core, terms which are the essential part of dispute resolution mechanism. So communication, coming back to this, communication is very, very important. Most of the disputes, or for that matter conflict, arises because either there is lack of communication or there's too much of communication. All right, so this, from this you can understand what is the importance of communication. So either there is too much, for which the other side is literally fed up, that why so much, I don't want to listen to all these things, or there's nothing. So both the extremes are wrong. Well, for that matter, extremes of everything is wrong. All right, but especially here. So either there is lack of communication or there is too much of communication. That's why there is discord, there is disagreement, there are these kind of differences happening. So communication is very, very important. Now, mind you, one of the important aspect of communication is to listen. So when we, and that's what we say in mediation, that you have to be, as a mediator, I'm saying, you have to be an active listener. Obviously, of course, you have to be an also equally active communicator, but more than that, before you can communicate or you should communicate, you have to be a very, very active listener. Now, this is also, there is also a difference between listening and hearing. When we say hearing is, now I'm sure all the participants here who are there today are hearing me out. All right. But I am also equally sure that many of them may not be listening to me, in the sense they may not be, or they may are not paying that attention, or they are not actually trying to understand what I'm saying. All right, that's what listening is. So listening means hearing and then analyzing what you have heard, and then putting your thoughts to that and trying to understand what you have heard. That's what listening is. That is the one of the main trait of a good mediator. All right, to listen, active listening. I'll come to the stages, and I'm sure, uh, uh, though I am not aware of the profiles of the participant, but I'm very sure many of you would have either experienced mediation or would have learned the techniques or would have been trained in mediation. So I'll briefly go into that process later on, but active listening is one of the core aspect of mediation. All right. So now we have understood conflict, we have understood dispute, we have understood communication. After communication, what happens? So one party says something, the other party listens. Then the other party says something, this party, the first party listens. So there is back and forth communication, and through this is what happens is what we call negotiation. All right. So let us now understand what is negotiation. Now, when we talk of, I mean, it's a it's a general term for that matter, but it has a very important aspect, because any dispute resolution happens because of negotiation. You call it even in court for to certain extent, there are negotiation happening. All right, like in US especially, you have the plea bargaining system. In many other jurisdictions, you will be having this plea bargaining. So what is that? You are negotiating. Plea bargaining, when you say bargaining is basically negotiating. The parties are negotiating on the same, their views on the same subject matter. Correct? That's what negotiation. So negotiation is what we call is the fundamental root of solving differences between the parties. All right. It is based on open communication. All right. And what is the purpose? The purpose is to find a common goal of mutually acceptable solution. That's the purpose. That's why you negotiate. You negotiate to try to find out a common goal of mutually acceptable solution. That's what is negotiation. That is what we call when we are saying we are negotiating. All right. Now, mind you, in negotiation, as I said, it happens only if there is a communication. Otherwise, you cannot have a silent negotiation. Though uh, it is an exception, many times widely used in mediation. I'll come to that when I talk of the aspect of time, the importance of time in mediation process. But generally speaking, negotiation happens with active communication. All right. So when we talk of negotiation, there are certain fundamental or different approaches to negotiation, in the sense that either you want a winning position and you don't care of the other side whether the other side loses or not, and that's what we call the adversarial process of negotiation. Then there is a tolerant way of negotiating. it is, it is basically with a view to preserve the relationship. That's the main purpose behind this kind of a negotiation. Then there is another model of cooperative negotiation, all right, which is more to do with mediation. So you forego something to gain something, and similarly you expect the other side to do the same. That's how it's called a cooperative model of negotiating. And similarly, same little similar to, I mean almost similar to that is what we call collaborative. In cooperative, there is an aspect of losing also, and there is aspect of win also. But in collaborative, you are taking as win-win situation. That's what is mediation. Win-win situation. Why? Because preserving the relationship, all right, both the parties go out happy, feeling that they have won their case. That is what we say when we say collaborative approach, and that's what is mediation. That's ultimately is what mediation is all about. And when we normally say it's a win-win situation, win-win situation, because it is balancing out both the parties' case. That's what. So this is the another way of negotiating. So when we talk of negotiating, what is the foundation of negotiation? And that foundation is one very important aspect, and which you must, when you are in mediation, you must always accept the element of unknown. You cannot every time know each and everything, all right, or you cannot predict each and everything what is going to come. So you have to accept that there's something unknown would be there, would be coming. And that's when we talk of this, it's called adaptability. Okay, you have to adapt yourself, be ready to adapt, be flexible to different situation. Adapt yourself, maybe if you are in position of mediator or in the position of parties or even the councils sitting in a mediation. Try to adapt, try to be flexible, to come out with more optimal solutions, options to a particular dispute. Then only you can have this win-win situation. Otherwise there is no point sitting in mediation. Then you better approach arbitration or the court for that matter. So this is a key to mediation. And therefore it is said that as I said, no matter how much we are prepared, all right, we can always run into surprises, twists and turns, unexpected barriers in whenever we are doing this negotiation communication with the other parties. So be ready with that. So therefore, now just to summarize what I discussed, so what are the three fundamental step or fundamental aspect of negotiation is listen and learn, one. Second, be flexible. And third, negotiate from knowledge and adaptation. These are the three key aspects of a good negotiation. And there is a very interesting book which I don't know, I mean, many of you would have read about it. And it's called In Getting to Yes. That's the title of the book. A very known and famous book, and very interesting for all those who want to learn about mediation or dispute resolution for that matter, negotiation, mediation, and all that. Now, in that book, the authors have identified four fundamental principles of successful negotiation. So what they have and what they say is, one, separate the people from the problem. And this actually is applicable to mediation. All right. So first they say separate the people from problem. Second, focus on interests rather than positions. Another very important aspect. Third, generate a variety of options. Okay, as I said, be flexible. And fourth, use objective standards. So this, if you adopt these four principles, I'm sure you can have a successful mediation. All right. So this is what negotiation is all about. And therefore, so what we have learned is we have learned about what is conflict, what is dispute, what is communication, and what negotiation. All this together makes up mediation. All right. Now coming to the mediation as such, I'll come to the topic, and when I'll give you examples to finally conclude whether mediation is actually the appropriate dispute resolution process or not. Will And I'm very sure at the end of my talk today, most of you would agree to this. Now, so coming back to what we were discussing about the some important aspect of mediation. There's another aspect what I was talking about is time. That is a strategy actually, but it's kind of a silent negotiation. When we talk, I also told you about that, though most of the time it's an active listening or active communication, but there can be silent negotiation on the. When I talk of silent negotiation, one form of that is time. Many times it happens that in conflict or in dispute, parties are at such level of their disagreement, that they are not ready to even go 1 inch forward. All right. Now, if that is a kind of impasse, if it happens, and if you are sitting as a mediator, the best way out at that particular moment is to postpone it for some time, give some time, because time, as we know, is the best healer. That's what the saying is, and it is a universal truth. All right. Time is the best healer. So try to give some time, and it has been seen that because of this time factor being given, many of the disputes have been resolved. Now let me give you a very interesting example of a land dispute between India and Bangladesh, which started years back. And the issue was, there were certain parcel of small lands uh, belonging to India, which were in Bangladesh, and surrounded by the Bangladesh territory, and certain parcels of Bangladesh surrounded by the Indian territory. So that was the situation, and I'm talking of years back when this the separation happened. And earlier during 1970s, both the countries' government tried to solve it out. There were even international, help and support being also taken. Unfortunately, uh, no solution could come out. So it was just left as it is. Now, imagine the situation of the people who were, residing in those uh, places. They didn't had even a simple basic infrastructure facility. All right. However, in 2015, again, government of both the countries decided to again give it a try and resolve the issue. Try to resolve the issue. Now here, both the government and the head of the state have their own also personal interest of resolving. All right. Now let's not go into the politics of that, but the important aspect is, given this time, and of course with the positive attitude and vision of both the governments, finally in 2015 this issue was resolved. So maybe it took more than 40 years. All right, but it still got resolved. So the idea was to make you understand how important the time factor sometimes, and especially in cross-border disputes, time is very important. You can see what is happening in Middle East and all those places. All right. it is a time which definitely and certainly would, resolve these disputes. However, time alone cannot, as I said, time alone cannot do it. You also have to supplement it with positive strategies, the positive mindset. All right. But yes, given a time, it will definitely, most of the time, it will get resolved. So time is also another important aspect what you have to keep in mind when you're doing a mediation. Now, again, let me give you another example. In a matrimonial dispute, all right, most of these disputes happens majority because of the ego issues of either parties. All right. Here also, again, given a time and considering the positions and the interests of the parties, you can definitely resolve these matrimonial disputes. So likewise, it is up to the mediator who how he or she is adopting different strategies in a given situation. So flexibility, as I said, adapting, you know, expecting unknown and then trying to evolve a strategy to that to work out the best solution. That's what is a trait of a good mediator. Now, again, when we're talking of mediation, in my view, mediation is more to do with emotions, feelings, interests of respective parties rather than their positions. Right? And when we are talking of emotions, we also have to understand again two interchangeably used word, but many times people are not realizing the importance, the difference between is what we say sympathy and empathy. Right? Sympathy is to an extent a lesser degree of feeling than what when we say that you have to show empathy. Empathy means that you are putting yourself in the shoes of the other side and understanding the problem. Right now, when let's say in case of someone's death, there is a prayer meeting. If we have any relation with that deceased person, we go and attend the prayer meeting. Now, do we sympathize or do we empathize in that? We are just sympathizing, okay? Because we, unless of course it's a very close person to you, some family, close friend, all right. Otherwise, you just sympathize. You sympathize means that you feel pity in a way, all right. You feel sorry, but when you actually feel what the other person who's left behind, the family members, maybe the wife, the children, or whosoever are there, parents, when you try to understand their feeling, how they are feeling, and then you try to console, that's what empathy is, and that is what is required in mediation. All right, you can very well sympathize by simple listening. All right, you can feel, okay, yeah, there's something wrong has been done to the person, some injustice being done to the person, there is suffering going on, but that's sympathy, but that is not going to solve the problem. So what you have to now, thereafter, you have to then understand why that person is behaving that way, why that person is feeling that way. So when you go beyond those feelings and understand their positions, then only you can come out with a best solutions to that problem, to that dispute. That's what the duty of a mediator is. That's what a trait of a wise mediator, to be more empathetic rather than sympathetic. Right? So, in nutshell, if I just take all this together and let us try to understand what mediation is now. So, I would say that mediation is a dynamic, structured, interactive, and voluntary process where an impartial, neutral third person, okay, facilitates the parties to reach a voluntary and mutually acceptable or amicable resolution of all or some of the disputes. So, if we break this in different important parts, first, it's voluntary, it's private, it cannot, you can, it is not out of compulsion, though now we have in many jurisdictions, including India, we have mandatory mediation, at least in commercial disputes, all right, which is made part of the law itself. But generally speaking, mediation, or for that matter, all the what we ADR process we say are voluntary, all right, and second, they are private. That is the another important aspect of mediation or ADR. They are private and voluntary. And when we say private and voluntary, of course, there is a important aspect of confidentiality involved into that. Whatever is discussed within the four corners of that room remains there only. It remains confident between the parties or between the parties and the mediator. All right. And at the same time, another aspect of mediation through this is where the parties feel, or the mediator as a third party neutral facilitates the party. So mediator is not there to sort of adjudicate or decide on the dispute. That's not the job of a mediator. The mediator is there to encourage, facilitates the parties to come to a amicable solution. All right. So basically, through the options, through the suggestions given by mediator, I'm sorry, the parties themselves try to find out a solution to their problem. And why we say this? Because it is the parties who obviously knows what the situation, what the problem are. All right. So definitely they are the best people to resolve it out. However, because as I said, because of the ego issues or many other circumstances, or reasons, they are not able to resolve the problem. That's why you need a third party, a third person, neutral, impartial person, to lead them towards a common solution. Right? So this is the beauty of mediation. It's so open-ended, and mind you, that's why uh, to an in countries like Hong Kong and Singapore, you have Mediation Act. But in my personal view, if you make this, you know, so open and flexible system within the four corners of a law, then I think we will be, it will lose it will lose its sheen. It will lose its importance of as a system as a whole. Because you need to be, when you are in mediation. Uh, Now, you would have learned, or you would have heard about uh, three basic, what do you call, types of mediation: facilitative, transformative, and evaluative. Now, I am saying why we are talking of these types. There is no type in mediation. It all depends upon case to case. You can either have a facilitative mode, you can adopt a fusion of, let's say, facilitative and transformative, or any whatever you want to, you feel like doing it. But the idea is, the final objective is to ensure to the fullest extent that the dispute is resolved. So you don't need to make it confined to a boundary. Why? Be open, be flexible, and that's what is required for a successful mediation. All right. Flexibility, that's the important aspect. So don't go by these selective types of mediation. You can evolve your own way, your own strategy. And as I said, the ultimate aim is to resolve the dispute. All right, that's the ultimate aim. So don't go by this, So let us not confine mediation into a boundary of rules and regulations. Of course, yes, I am not saying that there cannot be any rule as such, because if you give a free rein, then again there can be issues of public policies and many other things, your personal laws and all those stuff. So yes, there have to be some rule, but mediation definitely is much more closer to natural justice than any other dispute resolution mechanism. Okay, what common sense, what natural justice say, that's what mediation is. That is how you do mediation. Because, and that's what I say, I mean, that in court you get law, in mediation you get justice. You actually get justice in mediation, because you are going by common sense, you're going by natural law. That's why we say it's justice. In court, definitely court are bound to follow law, laid down law. They can't go beyond that. And many times we have seen, we have experienced that because of this law, we know even the judge himself or herself who is deciding that or giving the judgment knows that this is wrong, but he or she is helpless because of law. But this cannot happen in mediation. You can still have a win-win situation, that's what we say, and actual justice in mediation. Therefore, what I would say is, let's mediate and not litigate. That should be the aim. All right? And this is more important in today's scenario, what is happening, the pandemic situation where courts are not functioning properly. There are so much of backlog. In my personal view, mediation is the solution, the best solution to work out and work around the disputes. Now, again, let me give you an example. There are issues of, in commercial trade, issues of between landlord and tenant everywhere, all right, in general. Now, take example. Now, if you see from each party's perspective, let's say from the landlord's perspective, now they are right in demanding rent because they have given the premises. I mean, it hardly matters to them whether the tenant is able to use it or not. It's not their business. All right. So they are right in their way in demanding. They are very much valid demand. Now let us consider tenant's side. Tenant is saying that I am ready to use, but I am not able to use, or I have not been allowed to use because of the government regulations. So why I should be penalized with, why should I be paying the rent? I am ready to use. All right. So tenant is equally right. What do you do if this matter lands up in the court? It will be either in favor of, it can go either in favor of tenant or it can go either in favor of landlord. But is it going to actually give justice to both the parties? No, because they are right in their own way. So what is the solution? Solution is definitely mediation. You can try to work around some kind of semblance between the parties, come to some kind of a balance, a fair balance between the parties. Okay, lose some, gain some. Don't make them, you win, he lose. No, lose some, gain some, both sides. So it's fairly balanced, and that can happen only in mediation. So likewise, you take any dispute for that matter. Forget about the core. I mean the core criminal matters for that matter. But generally speaking, those disputes which can be arbitrated can definitely be mediated. However, the reverse is not true, mind you. But this is definitely a fact that those disputes that can be arbitrated can certainly be mediated. And I'm saying should be mediated. That's why we are now hearing the concept of MedArb and ArbMed, Why? Because ultimately, you see, as I said, ultimately, what is the basic purpose of ADM is to resolve the dispute by way of maybe adjudication or whatever. But this is the ultimate aim. The parties have approached a mediator or an arbitrator for what purpose? To resolve the dispute. All right, that's the main purpose. So, so keeping this ultimate aim in mind, it is just a strategy what you adopt. MedArb, made mediation, arbitration, whatever. That's the strategies. So when we talk of these strategies, is what I say is choice. There's a term called choice. Now, what is choice? Again, let us understand. Because you see, we are speaking these words, these terms in our day-to-day life without many times understanding, and at least not understanding in the context of ADR or dispute resolution for that matter. So that is understand. That's why I started with these basic. You, I know many of you saying, "What is this?" We all know what, but then you have to understand this in context of dispute resolution. Why we are discussing this? That's the importance of each term what we discussed today. So what is choice? Choice is the ability to make decisions given two or more options. All right, that's what the choice is. It's an expression of a person's free will. When we say you make a choice, what you are doing, okay? Given a set of options, you are choosing through your own discretion. All right, so you're making some decision to one, or you're picking up one option. That's a choice. So when we say choice, it is made up of five basic needs. Why you're making that choice? Again, how, why, when. These are the questions. So why you're making that choice? The reasons are survival, belonging, that is ownership, power, freedom, and happiness. These are the five reasons why a person would make a particular choice. So coming back to dispute resolution, which dispute resolution mechanism you want to choose depends upon what you ultimately want to achieve. If you want a partial initial relief, all right, maybe uh, if you want a win-lose situation, you want a win-win situation, you want a partial relief, you want a full judgment, you want a final decision, you want a interim decision. These are the reasons or issues which will make you lead to choose a particular dispute resolution mechanism. So that is what choice is, and there is a saying that everything in your life is a reflection of your choice. If you want different result, make different choice. Now, applying this in dispute resolution, if you want a win-win situation, go with mediation. If you want a win-lose, you have so many options. You can go to arbitration, you can go to litigation, or any other mode. So it is your choice ultimately. What system, which mechanism you adopt. This is your choice. So now, coming lastly to today's topic, if we analyze what we discussed, and as I said, everything which can be arbitrated or litigated can certainly be mediated, then definitely mediation is the appropriate dispute resolution mechanism. I think now we should be using, instead of alternate, we should be start using the word appropriate, and that's why I have requested, when the center approached me for the topic, I said let's put this term appropriate dispute resolution process. When we say appropriate, we are what we are actually achieving. what we are aiming at. We are aiming at fairness, a balanced, kind of a solution for both the parties. That's what we say appropriate. When we say appropriate, what do you mean by appropriate? That it is true in all the sense, whether it is party A or party B. Both the parties feel that it is correct. That's what appropriate is. All right. That's why, and that is what mediation is, where the parties actually get a justice in the true sense. That's why I say mediation is the appropriate dispute resolution process. Thank you very much.
Thank you, Thank you, Mr. Shah. It was indeed a very insightful and a very informative uh, talk, which I'm sure the audience would be reflecting in their own time and would be utilizing it while they're deciding to choose their career as a mediator. So I have, let's move on to the second part of the session. I have certain questions for you. The
Mhm.
first question being that you have talked about mediation being an appropriate uh, dispute resolution process. Other than matrimonial disputes, could you tell us about what are the areas in which mediation would be considered as an appropriate way to resolve dispute?
I think the the person who has asked this question was not listening to me because I said that whatever all those disputes that can be arbitrated or litigated can certainly be mediated, meaning thereby you can mediate all or any disputes. Forget, of course, about the criminal aspect, but in many criminal aspects also, like fraud, for example, in economic offenses. All
Mm.
right, there are judgments in India now, and I'm sure in many other jurisdictions, where mediation has been, taken help of to resolve that. In fact, courts have now started promoting mediation in a big way. So there's nothing which you cannot mediate, except, as I said, yeah, of course, something which is going to affect a person's life and liberty. Definitely, you may not mediate that aspect, but otherwise than that, you can definitely mediate. You take it, trading disputes, which we, in a broader sense, we say commercial disputes,
Yeah.
maritime, intellectual property, you name it, you can definitely mediate it. There is no, as such, sort of exhaustive list of dispute which cannot be or which can be mediated for that. I'm saying you can definitely mediate any dispute, provided, of course, both the parties should agree to that. Yeah.
Right. Thank you for your answer. There's another question which is about, you talked about commercial model businesses, right? So my question to you is mediation the appropriate dispute resolution for all the type of commercial model businesses, be it low commercial, be it high commercial? Or do you think, since you're also an arbitrator, or arbitration is a better solution in resolving to dispute within the parties, subject to the fact that the parties have agreed to it?
Definitely, I mean, you are. I would agree to an extent that though mediation, we say, and what I also agree that it's an appropriate dispute resolution process, but many times it may not work out successfully. Like if there is a total imbalance between the positions of two parties, where one party is in a position to influence or try to have more power on the other party, then definitely mediation may not work out. There you may have to go with the adjudicative model, maybe arbitration or litigation. All right, to protect the other party who's being affected as such. So many times it happens. So it all depends upon definitely the in what positions the parties are, what are the case circumstances of a particular case, and that's why I said that nowadays this new fusion or hybrid models of dispute resolution like MedArb or ArbMed are being evolved. This is the reason.
Right. Thank you, sir, again for the for answering the question. I would like to, since you are working as a mediator and arbitrator, could you share us with about some of your personal experiences where mediation was proved to be a better solution or the more appropriate resolution to resolve the dispute over the arbitration cases that you have done?
Yeah, I tell you, I'm actually currently involved in a very highly contested family dispute. And what I have, when the agreed party approached me, uh, from the very beginning, I had advised them to go for mediation rather than litigation, because there is no end to litigation, all right, and there is no certainty so far as time, cost, and of course the result in litigation. Now, so I suggested that, if you really want uh, a peace of mind for that matter, and to see that, you get what actually belongs to you, all right, or legally speaking, or what you actually want, demanding for that matter, in a fair manner, without much cost, and in time bound manner, then you must go with mediation. And thankfully, because of that, it was successful, and we could resolve that matter. So I could have taken them to arbitration also for that matter. But now what I will be doing, and what I have suggested, once we settle out in mediation, definitely we would make it a kind of a consent award, all right, to put it, to make it, give it a weightage of the court decree for that matter, because unfortunately, um, the mediated settlement agreement are not given that weightage, that recognition, as an arbitral award or a court decree. So, but till that time it happens, till that time it is given that kind of a recognition, we need to, put these kind of hybrid structures to, of mediated settlement being converted into, let's say, an arbitral award, consent arbitral award, or maybe put it before the court and to get a consent decree, whatever. So, as I said, this in this case, because it also involved a family or with two minor children, I suggested, that you go with mediation to cut short on time and cost, and to ensure the result what you want.
Right. Thank you, sir. I just have a follow-up question in the scenario that you have discussed. Um, are you of the opinion that if mediation is given a footing, as in the award, say for example, the solution provided in a mediation is given the status of an award that is given in an arbitration, do you think it would blur the distinction between a mediation and arbitration, or wouldn't that be binding again at the end of the day?
I think it will not. I mean, there is no issue of blurring the distinction between arbitration and mediation. I would, in fact, of the opinion that, mediation, unfortunately, has not been given that recognition, that importance, uh, what it should be given, and more so, uh, and that is the reason, when we say it's mediated settlement agreement. Now, when we say agreement, meaning thereby there's still something for the parties yet to be performed. That's what an agreement is, right? If you understand the term agreement, what is agreement? Agreement is that two parties come together and agree that they will do this or they will not do this. So there is some action still more to be taken by the parties. That's what an agreement. Therefore, even when we talk of mediated settlement agreement, all right, there is something more to be then yet to be performed by the parties. So there is no certainty, there is no finality to it. At the same time, if we are saying that it is a mediated settlement, now we are, see, this is the problem, this is the contradiction. We are saying settlement, and then we are saying agreement.
Mm.
Now, when we say settlement, there is no further need to do anything else. All right? But no, we are saying it's an agreement. So this is a contradiction, unfortunately. Till the time this contradiction is not removed, I think mediation will not get that importance, what it actually requires. So we must definitely give that weightage to this kind of a solution which comes in a mediation through two parties coming to a settlement. Just why can't we say mediated settlement? Why we need to add the term agreement to it? We can simply say it's a mediated settlement. That's it. Full stop.
Right.
But till the time this happens, I think we still have to go with the two process of a settlement agreement converted either into an arbitral award or a consent court decree.
Right. Thank you, sir, again. That was a very nice way to put, and I'm sure the audience have understood the importance and why importance to mediation and recognition is to be given. So you mentioned about the cross-border dispute, that time is the best healer. But that was one of the prime issue. For example, it's a cross-border dispute. But how do you think mediation would be the solution, the being an inverted comma, for dispute that happens in our daily lives? For example, the tenant, or for example, my mate coming and saying that, you're supposed to pay me this, but you did not pay me that, and I say you did not come for those days. So how do you think the impact of mediation would be in our daily lives, as opposed to
Well,
something important like that?
I
Yeah.
think it is of great importance in our day-to-day life. Um, and, and just taking your example of that maid, what you just said, let us try to understand that in a different
Contact.
resolution systems.
Hmm.
So what has happened is that maid is saying that you have not paid me, and you are saying that why should I pay? I mean, that's the example what I've given of a landlord and a tenant. All right, probably the maid is right in her own way. All right, and you may be also right in your own way, because you said that you have not come, and the maid has said that it's because of maybe some urgent issue at her family, maybe she was not well, something would have happened, some genuine reason. All right, so now what to do? Now let's say you take a final decision saying that I am not going to pay you. The maid can say, fine, then I am not going to work. Who's going to suffer?
Me, myself.
Both, no, both of you.
Both of them, yeah.
Both of you. The maid would be losing the money,
The money.
all right, and you will be obviously losing the services. So both of you are going to suffer.
True.
In a general way, I am saying. Though there can be different circumstances, but let's try to understand in a general way of understanding. So both of you are going to suffer. So why do that? Take a midway. There is always a midway. You can definitely work. This is not a big deal about it. You try to understand her situation. That yes, definitely there might be some genuine reason. Let's say maybe she was not well. There was some emergency at her family. Something, all right. And at the same time, she would also understand that yes, let's say there was something not that important, but yes, she would also try to understand through, of course, negotiation and communication, effective and proper communication, without those egos flaring and actions being taken. Both sides try to understand each other and work out a solution. Here also, you see, ultimately, again, the power balance of parties are also important. The needs of the parties are equally important. Now, it may be possible that you are more in need than her. She might get some other place to work for. Who's at more need? All right, you probably, correct. So you have to then work that way out when you're negotiating. So definitely, mediation must be, I would say, used in definitely in our day-to-day issues, rather than taking it to the court.
Right. Thank you so much for answering that. Uh, just I wouldn't say a follow-up question, but just a point about timing. Uh, you mentioned that the cross border was resolved in 2015. So time they could take time and sit and think about the process and think what has happened and then reach a solution to it. uh, and also my question is that sometimes time can be of crucial importance. For example, in Bangladesh we have an act, a code of civil procedure, where in section 89 it talks about mediation. So if I file a case and courts actually encourage us to mediate first, you file the case, okay, solve it, go for mediation. However, there's a time limit to it, that it has to be finished within 60 days, and that can be for extended till 30 days. So in total, there is 90 days to solve it through mediation. Now, my question is that you mentioned that this has been an hindrance, but practically speaking, what are the real problems associated with it?
Well, you see, we also have a similar provision in our Code of Civil Procedure.
Citizen.
All right.
Yeah.
And in my view, I, and I think what you said is actually agreeing to what I said, in the sense that time is the best healer. You must give, many times, you have to give more time to make the parties understand their respective positions. Now, likewise, if, and that's why the mandatory mediation in India is not working that well. If, because if you are, if you put as, and that's what I said, that if you are confining mediation, which is a very very flexible system process, to a set of rules and timelines, it's not going to work, because it happens that many times you need more time for the for the parties to understand their respective positions and position of the other side also. The mediator may need more time to evolve out options. All right. So it may not happen in 3 months. You may need 6 months. So what's wrong in that? However, the counter to this is equally important. How long you're going to work,
Right.
how long you're going to do. All right.
Exactly.
So let's try, let's take case to case basis, you know, and or maybe put a reasonable timelines. 3 months is nothing in a commercial dispute. Let's say, and the problem is you're not defining a pecuniary limit to a commercial dispute. Any commercial dispute, for that matter, has to be now mandatorily mediated. So it can be, 10,000, or it can be $1 million. But a $10,000 case would need a different set of strategies than $1 million case. All right. You may not
Exactly.
be able to resolve a $1 million case in 2 months' time or 3 months' time, but you can definitely do it for the 10,000. Why waste time and for this? It's not that big stake thing. So likewise, there are many other issues involved. But as I'm saying that, still, if you confine mediation to timelines, like strict timelines of 3 months or whatever, 4 months, that is actually would go against the whole concept of mediation.
Right. Thank you, sir, for clarifying. And I do agree with you. It is actually, to some extent, and for very important cases, it is actually a hindrance, sort of takes away the significance of having a flexible system. In light of COVID, as you have initially pointed out in your talk, um, we have, how effective is the virtual mediation in these terms?
Well, you are, we are experiencing this. We are today online. We have conducted this seminar, and uh, maybe the participants are from across
Where,
the globe, for that matter. But we are all together here. But it would not have been possible in person. All right. So when we talk of online, definitely it is going to be the future. uh, you cannot ignore the importance of online dispute resolution mechanism. Secondly, it is much more flexible. All right, it saves cost, it saves time. Let me. I was just talking with one of my colleague before this seminar, and I said that somewhere when this lockdown started, I think in the end of March or early April, I was involved in a international mediation relating to employer-employee issues. All right, Now the complainant or the claimant was in London. His attorney was in Nigeria. I was in India. My client was in Philippines, and the mediator was in New Zealand. Now this would not have been possible in person. I mean, of course, at that situation, it would have involved huge cost. All right, bringing all these people together at one place and at the same time. But we worked, and for me, it was 3 a.m. in the morning because of the time zone difference. But we still worked. So this could have happened because it was online. So you have that flexibility. Uh, from wherever you are, what you need is a good internet connection and maybe a smartphone. That's it. Nothing more. You don't need a venue. You don't need all those peripherals attached to an in-person hearings. And now, thankfully, because of the technology, you have these kind of efficient ODR platforms, which are much more efficient, or they work actually like a virtual, or in-person hearings. So then, why not use it? I think that is going to be the future. Maybe not as a whole, but definitely uh, we are looking towards a more hybrid model of online and in-person system.
Right. Thank you, Mr. Shah, again. Mr. Shah, I would entertain few more questions because we
Yeah,
are almost over the time, if that is all right with you.
yeah, yeah. Please.
All right. You have also nurtured and tutored students who wanted to be mediators. So my question to you is, what are the problems that, or what are the very crucial parts that you have faced while uh, nurturing someone or conducting training sessions for the mediator, for the potential mediators and arbitrators?
See, I would answer this in a different context, but it will definitely get answered. I would, rather than what problems I have faced, I would say that what are the important traits which is required for a person to become a good mediator, right? And to me, the most important, for that matter, not only for mediators, for any position, anything you want to become in your career, the most important aspect is your passion. You should be passionate about that particular subject. Now, talking of mediation, are you a person who likes conflict, who likes to sit with conflicts, or who you know who get just want to disassociate himself or herself with the conflict? If you are the second category, then you cannot become a mediator. If you love conflict, that's that's important, right? Why? Because if you run away from conflict, how are you going to suggest solution to the parties? So your passion, your interest, that is more important, I think, and that is what I have faced so far as when I've been training the students for that, more particularly the students for that matter. What I've found is, many times they have come there because of either compulsion or just, you know, sort of, not that interest into that, but just to see, okay, let's see what is this, you know, not with that active interest. Maybe many times because of uh, the system as such, because it's part of the curriculum, so they have to be there. Though not earlier, but now, in fact, in India, it has become a mandatory part of the curriculum. The mediation training and mediation as such is a subject in the law school curriculum now. But as I said, so this interest, if you don't have that passion, then I think you cannot become a good mediator. Secondly, your the different traits of, as I said, mentioning the active listener. You have to be active. If you are impatient yourself, then I don't think you can be a good mediator. You have to be a very, very good listener, not hearing, listening. All right. And then uh, another important aspect, you must also have a good knowledge of basic human psychology. And that goes not even with mediators, it goes with even arbitrators or for lawyers also. You must have basic understanding of human psychology, because in mediation, or for that matter in arbitration, court litigation, or when you are sitting with your client, we are day in day out interacting with humans. And especially in mediation, you need to understand the body language, the meaning out of their eye contacts, their facial expressions. the, this will come only when you learn the traits of basic human psychology, and that's very important. This is very important strategy in mediation, right? So I think these are the things which someone who is thinking of going into mediation, I think, not to discourage, but for me, if you ask me, I think mediation is much more difficult than arbitration. Why? Because in mediation, you are actually you're supposed to go against the basic human tendency of not to speak. See, humans by nature, we have that nature. That's a basic mentality that we speak. All right, but this is what is not a good trait of a mediator. You're not there to speak, more to listen, less to speak. So if you have this kind of a uh, mentality, your approach, your mindset, then definitely you can be a good mediator. But this is very difficult. So that this all comes through your trainings, your experiences.
Right. Thank you, Mr. Shah. I'm sure the audiences who are here and listening to us today would be highly beneficial from the advice. I absolutely agree with Mr. Shah that these are the very important traits that are crucial for you to be, even sitting as a mediator. So, Mr. Shah, the follow-up question to you, and I assume this will be the last question for the session, uh, is that you mentioned the tutoring, you mentioned the process and the courses that are important, to be a mediator. Could you advise our audience about what are the courses that one has to take to be, a mediator, if not a successful mediator, because that comes with experience? Yeah.
Well, there are many of the institutions for giving, you know, trainings on mediation, and definitely CIR is the one of the best course to be taken if you are really thinking of mediation as such. Uh, then you also have the AAA ICADR, which is the American arbitration. They also conduct a good this training of mediation. You have CEDR, which is Europe based. So I think these are, in Asia, of course, you have the Singapore International Mediation Center.
Yeah.
Uh, they do good and good accredited training. So you can, I mean, there are other, but to me, I mean, these are some of the best institutions whom you can think of if you really want to pursue or want to take a training in mediation on an international level.
Right. Thank you so much, Mr. Shah. The audience, I hope you have taken notes and the important advice that Mr. Shah has given us today. Uh, Again, I am thankful for CIDR's platform to give me the opportunity, and foremost importantly, we are grateful to Mr. Shah, to you, Mr. Shah, to bring out your clear out your schedule or squeeze in our session in your busy schedule. Thank you again for coming here and making time for us. It is indeed our distinct honor to have you here.
Thank you so much, and I also feel so pleasured and privileged to be on this platform, and especially thank you to Mr. Abdullah, to give me this opportunity, and to all at CIADR. And definitely, let's look forward for much more these kind of interactive sessions in future.
Yeah. Thank you so much for coming and
Thank you so much.
participating. Thank you.